Okay, well, good morning, everybody. Welcome back to the Wednesday CLE, free CLE at the Travis County Probate Court. Today, our speaker is Megan Miller-Inoue, and she will be speaking on the uncontested probate docket, getting it right the first time. And the course is scheduled to go from 10:30 till noon, so it's an hour and a half CLE, and hope we can get you out of here in time for lunch. And before I go into talking about our speaker, just want to let you know our next CLE, we don't have a scheduled date yet. Actually, we do. We just scheduled it. Mike Jones, our senior staff attorney, will be presenting on heirships for applicants, attorneys, and the attorneys ad litem. And I believe that is set for Wednesday, May 25th. Is that correct, Mike?
Yes, sir, that's correct.
Okay. All right, and we'll get that posted. We usually open up a registration 2 weeks beforehand. That as well will be remote. I think eventually we go back in person, but for today and for the May CLEs, we will do those remotely. All right, well, turning our attention to today's CLE, Megan is our 2-year law clerk staff attorney at Judge Guy Herman. Her position usually goes until the end of this summer and the fall when we bring on our new law clerk. However, Megan will be leaving us at the end of this month. Some of you may have already been made aware of this. We made the announcement at the last CLE, the paralegal program. But Megan is going to enjoy the summer and also assist her family. She's got some family matters to take care of that are out of state. And so she's planning on leaving here. I think your last day is April 29th. Is that correct? Last day of April, last work day of April.
Yep, April 29th, yeah.
So she will be sadly missed. She is a very welcome addition to the court. And it's been an interesting 1.5, 2 years. You were with the court longer than the 2-year position, but it seems like for the most part you're here during times of COVID, so it's a more unique experience for the 2-year law clerk. But we thank you for everything you've done, and especially being able to do I feel like this is a rite of passage, having the law clerk teach the uncontested docket CLE. Usually we do that about 2 months into your 2-year clerkship. So it's a little bit more kind of going on the fly, but you've had a 1.5 years to have this stuff down. So now you're an expert at it, and you'll be able to tell everyone what we need to do to get the uncontested docket right the first time. So with this, I will turn it over to you, Megan. And I think we just got one other person coming in, and then you can proceed.
Okay. Can everyone see my share screen? Okay.
Yep, looks good to me.
Okay. Yeah, so we're going to do the uncontested docket, getting it right the first time. As Tom mentioned, if you guys have any questions, please feel free to just shoot them in the chat. Mike is going to be watching the chat. And then I'm also going to try and watch the chat. You can also use the hand raising feature on Zoom if you're comfortable doing that. I know most attorneys like hearing themselves talk. I am not one of those attorneys. So if you have questions, please ask them, because I'd much rather get lots of questions than me just talking into the void of Zoom. So please ask your questions. Also ask your questions, because Mike and I have been we've reviewed thousands of cases, so we get so used to the nuances. So if we're saying something, or if I'm skimming over something and you have questions on it or you need clarity on it, please feel free to ask me, okay? Because I'm always happy to elaborate on anything that I'm talking about. So today we're going to talk about just the logistics of the uncontested docket. We're going to talk about reviewing the will and identifying problems that are in the will. We're going to talk about the core filings besides the will. We're going to talk about the proposed documents and what needs to be in those proposed documents. And we're going to talk briefly about the uncontested record cases. However, airships can go in the uncontested record cases, but we're not going to be talking about those today because Mike's going to do a CLE on those next month. So first, the uncontested docket logistics. So these are the common, just logistical questions we get asked. When is the uncontested docket? It's every Tuesday and Thursday from 8:30 to 10 a.m. We currently are having a very limited Friday afternoon Zoom docket for uncontested cases, but these are only for non-record cases. And like I said, it's very limited. We're only putting about 6 cases on it right now because we are transitioning back to in-person. How do you set on the uncontested docket? You need to email Emma at probate.hearings@traviscountytx.gov. Do not email Mike and I. Please don't email us because we'll just refer you to Emma. And so it helps you skip a step by just emailing her directly. Make sure in your email you include the cause number and the estate name. Also, if you have back and forth communication with Emma to set, make sure that you just keep it all on the same email chain, okay? Don't keep creating new emails for the same case. Also, make sure when you're setting with her, you respond with at least 2 dates that are available for you and your clients, because our uncontested docket does fill up very quickly. So to minimize that back and forth with her, just pick several dates and then she'll pick the first one that's available. Okay, so once you've been set and you've been confirmed with your hearing, then you're gonna wanna email your proposed documents to Mike. You can also email them to me in this next month, but as Tom mentioned, I will be leaving the clerkship the end of this month. So it's good to just get in the habit right now, just emailing Mike until the new law clerk comes on in the fall. Make sure you send your proposed documents in Word format, or they can be in WordPerfect or like the rich text format, just anything that's editable. We will not accept PDFs. So another common question we have is what should go on the uncontested docket? We only put on our uncontested docket your straightforward, your vanilla 5-minute will probates, okay? So that's just your straightforward letters if you have a straightforward independent administration with will annexed, or if you have a muniment of title. What should not go on the uncontested docket are contested cases, declaratory judgments, temporary administrations, family settlement agreements, or any case that has like, you know, the will's a little funky, the situation is a little odd, something that will take longer than the quick 5-minute prove up. Just because we say it's the uncontested docket does not mean that if a declaratory judgment or a family settlement agreement is uncontested, that case can go on the uncontested docket. Because these declaratory judgments, family settlement agreements, temporary administrations, they just take a little more time. Judge Herman likes to ask a few more questions, and so we just like those always going on the regular docket. Okay, do you guys have any questions about the logistics? No? Okay. Moving on. So reviewing the will, and let's talk about also identifying all the problems when we're reviewing the will. So when we're talking about reviewing the will, the interesting thing is, as I talk about these, I'm going to try and keep it as linear as possible for everyone. However, be aware that because there's a lot of exceptions involved, a lot of different factors come into play. So I'm going to try and keep it as linear, as straightforward as possible, so we're not doing circles. So if I say something like, oh, it'll require this, we're going to talk about it later, just bear with me, because I'm trying to make it so we're not just going in circles the whole time. So the first question you need to ask is the probate within 4 years of the decedent's death. So what this means, if it is, that means that you filed your original application within 4 years of the decedent's death. So if you file an amended application after the 4 years, that's okay. What problems we've been running into recently is that an original application will be filed within 4 years, but then no action happens on the case and we end up DWOPing the case, dismissing it for want of prosecution. And then what happens is then a different attorney return is on the case and the client needs to refile for whatever reason. And then they try to say that when they reopen the case, they try to say that it's within 4 years. Because the case was DWOP, that case is closed And so whatever filings you do after that DWOP are all new filings. So therefore you're now after the 4-year mark. So that's definitely something you need to be aware of. We used to not see that very often, but I'm starting to notice it a lot more. So just kind of be aware of that.
Hey, Megan, I have a question.
Yeah.
Let's say I start a filing and then life kind of gets in the way and I don't get this probate done within 4 years, but the court doesn't DWOP it. And then I decide to get my stuff together and come back and finish the probate. Do I then need to redo it, or can I still rely on the initial filing date?
You can still rely on the initial filing date and you lucked out. You can still rely on the initial filing date. Another thing that also brings up a good point, just because what matters is the original filing date. It does not matter if the hearing is held within the 4 years of the decedent's death. It just matters that the application was filed within 4 years. So when you meet that 4-year requirement, then life gets a lot easier for you, and you're not going to have the additional muniment over 4 years requirements that you'll have to do. But what happens if you're not within those 4 years? If you're not within those 4 years, then you're going to need to start looking into doing a muniment of title over 4 years, because Judge Herman is not going to grant an administration. So, and that requires some additional requirements. We're going to talk about them near the end of the CLE in more depth, but just a quick overview. The applicant has to prove they're not in default for failing to probate within the 4 years. You're going to have an attorney ad litem appointed. You're going to have some additional proof, and you're going to have all the heirs and distributees sign the waivers or be personally served. So you have these additional hoops you have to jump through. So it's always better to just try and get it in within those 4 years. But obviously life happens, the client doesn't realize it needs to be probated, and then so sometimes you're falling into that bucket of doing a title over 4 years. So the next question you want to ask is, okay, is the will an original? If it's an original, then great, you don't have additional requirements. If it is not an original, then you're going to have to go with the probate of a copy of the will. And similar to a muniment over 4 years, you're going to have to overcome the presumption of revocation. You're going to have an ad litem appointed. You're going to have additional proof, and everyone needs to be waived or personally served. But then you're probably asking, well, Megan, how do I tell if the will is original? That's a great question. And that is a question that we have been running into a lot lately. So the best test, and the test that we recommend you start off with, is the spit test. So if the spit test, gist of it is you're taking water or spit and you are rubbing it on the will to see if there's any smear. If just the stamp smears, then it's likely an original. If everything smears, so the stamp smears, signature smears, the text, the body of the will smears, then you likely have just a bad photocopy. If you're not sure, if nothing's really smearing, there's also a possibility of nothing smearing that it's also a photocopy. But if you're just not sure, go ahead and bring it into the court and we'll take a look at it. We'd always rather take a look in advance so that no one's surprised. Once the case is set, you're not surprised, your client's not surprised, we're not surprised. So it just minimizes the complications down the road when you're setting the case. Some other ways to tell, look at the back of the pages to see if there's indents from the signatures. Also look to see if there's any bleed through on the back of the pages. You'll often see this around the stamp, or if, instead of like a thicker pen, like sometimes felt pens will bleed through, although sometimes felt pens won't. So that's definitely something else you need to look out for. Also, if there's a raised notary seal, that is the easiest way to tell that it's an original. And then lastly, make sure, pull out your magnifying glass if you need to, and look closely at the signature to see if there is any pixelation in the signature. Okay, so sorry guys. So what is interesting is that we're seeing a lot of colored copies coming into the court right now. So that's why I mentioned that, see if there's any pixelation in the signatures. Just because the signatures are blue does not necessarily mean that it's the original. It used to be that way, but it's just not the case anymore because we have very good color copiers now. So what you definitely want to do is grab your magnifying glass. If you don't have a magnifying glass, I'd recommend you get one. We use them at the court all the time. and just look at the signatures. Do they look like there are several colors making up that signature? If that's the case, then it's likely a copy, because a blue pen, it'll look completely blue. Whereas if you're using a color copier, there's no blue ink, so it's usually a mix of colors. Also, do the signature overlap the black signature line? Or is there a break in the swoosh of the signature? That sounds interesting to say, but often with a printed copy, it is not possible for the printer to make the swoosh overlap the black signature line. Whereas if you were doing it in person, that swoosh would automatically happen. So definitely just be aware of that. When the court determines the will is a copy, be aware that we get multiple set of eyes looking at that will before we tell the attorney. Because we don't want to make that mistake, because if we're making that mistake, you know, that's more time and effort and money for you and your clients. It's also more time and effort on the court's end as well. So we always try at a minimum to have Mike and I looking at it and one of the judges looking at it. So if we're saying something's a copy, it's not just a quick, we looked at it for 2 seconds and it's a copy. We did really look into it. If you think you filed an original, but we say it's a copy, please feel free to come to the court. And we're happy to look at it with you, walk you through how we made the determination. You can walk us through why you think it's an original. That is not a problem. Fortunately, the majority of the time that the court says we have a copy, the attorney will then email the client or talk to the client. The client will go back through their documents, and often they find the original. And that's the majority of the time. So usually what happens is, you know, you're making copies of the will. They've probably made copies of the will too at home. And then what they just mixed up the copies with the original. And so luckily it's always found. Maybe not always, but usually it's found. So make sure you just always encourage the client to double check everything. So the next thing you want to look at once you determine if the will is an original or if it's a copy, you want to look at, is the will internally consistent? So you want to make sure you're counting the pages, you want to look at the page numbers, and you just want to ensure that everything matches. You also want to make sure the paper, the types of paper are also similar, because if they're different, that could also be an indication it's a copy. So once you take a look at that, depending on what you see, some different problems can arise. If everything's consistent, then there's no red flags. If a page of the will is missing and there's evidence that a page was not included in the original signed will, then we may require some additional prove up, and we may require declaratory judgment. The most common one we see is this example 2. So if a will is missing a page and a photocopy of the page is found, the court will typically require that the will be probated as a partial original and partial copy. And when this happens, then you need to do all the requirements for a copy of a will. And this is what we find the most. But once again, if you find something like this, then please, double check with your client, because what happened is when the copies could have been made, one of the original pages could have been put in with a copy of the will, which we have had happen before. And the attorney found that original page within a copy. So just always double check. And then, yeah.
Chuck Rusink asks, are there any special exceptions being made for wills signed during the COVID-19 in Zoom executions under the governor's orders?
We have not seen many cases come up. I think we've had one come up right near the beginning of COVID. So I would just need, if one does come up, I'll just need to double check and see, if the order was extended and look at those requirements. But usually we've had one and there was no issues with it being probated. They did do a little bit of additional prove up with the notary, but there weren't any problems. So if you have one of those come up, just give the court a heads up, and that just gives us time to just double check everything, make sure everyone's on the same page with it.
And just to add on to that a little bit, it's been a while since I read that emergency order, but I do believe that it was a requirement that the notary not need to be there and they could use Zoom. but I don't know if it said anything about witnesses not needing to be in the same presence as the testator. So if that was not done, that may be something you need to provide evidence on.
Yep, great point, Mike. Okay, and then the last example, if the face of the will says it has a different number of pages than are actually included. So sometimes at the end of the will, it says this will consists of 12 pages, but the will actually consists of 11 pages. Then the court will probably require a subscribing witness or a notary to testify. So if you ever see one of these inconsistencies with like page numbers or anything like that, immediately bring it to the court's attention. We always like to have heads up with the funky cases. We like to have a heads up in advance of the hearing, just because, just like you guys don't like to be surprised when we send out an email saying, hey, it's a copy, or hey, something's off here. We also don't like to be surprised because we want to make sure that judge can look at it in advance of the hearing, make sure everything's okay, make sure we have a chance to double check everything. So always please just give us a heads up. So the next thing you want to double check is the will actually valid. So for a holographic will, it needs to be wholly in the decedent's handwriting and signed by the decedent. A form will is not a holographic will. We have had that come up in the court recently. A great way to kind of tell is if you were to remove all of the typewriting on that document, would it still make sense? Or would you be left with, you know, just the decedent's name, a executor's name, an address, so it's not flowing and being coherent. If the will is signed, if it's a holographic will and is signed by 2 witnesses, then it is not a holographic will. It is actually an attested will. Okay, so you will want to make sure in your application and in all your proposed documents, you do not call it a holographic will, because at that point it has transitioned to an attested will.
Hey, Megan.
Yeah.
We have an anonymous question. What if the client gives an attorney a will with pages out of order?
That is a great question. If the pages are out of order, we have not seen this in a long time. I believe they can rearrange them. That shouldn't be an issue, right, Mike? Have you seen one recently?
I haven't seen us get something out of order, but I have seen wills that come in that were completely holographic, and 2 of the pages were very similar, and they ended up being in the same folder where the will was found. And so it kind of, everything was provided to us, and we sort of had to suss out what was part of the will and what wasn't based on, does this ending sentence of 1 page flow into a sentence that makes sense on the next page, etc. If they come in out of order and you can tell, you know, it goes 1, 5, 3, etc., you can rearrange them in the correct order when you file it. I don't think anybody's gonna give you a hard time about that.
Okay, yeah, I think that's, yeah, if you're ever unsure, you can always just file it as is and we'll take a look and figure it out. Because I mean, it is often too, sometimes when the clerk scans stuff, the self-proving affidavit sometimes ends up before like the will signature page. And, you know, Mike and I will just take those apart and put them back together correctly. So I don't think it should be a problem for you to rearrange them if you're clear on the order of the pages. That is a really good question. Okay, so another thing to note that we've been seeing recently with holographic wills is sometimes they are notarized or they have 1 witness signing them. And that's okay. That's not too, it's not too big of a red flag for us. It might alarm you guys because then you're like, well, is it no longer a valid holographic will? It's okay, because Judge Herman will just consider that additional signature as surplus. And so we'll just kind of ignore it and still probate it as a holographic will. The issue is if you have, you know, 2 witnesses signing it, or, you know, just more than that one, because then you're transitioning into an attested will. For attested wills, it needs to be in writing. It needs to be signed by the testator, or it can be signed by another person at the direction of the testator in their behalf. And it needs to be signed by 2 credible witnesses in the testator's presence that are 14 or older. Okay, any questions on that? No? Okay, all right, you guys are pretty quiet. Okay, so What if the will doesn't have signatures, but the self-proving affidavit does? That's no problem. What we'll just do then is we'll take those signatures that are on the self-proving affidavit, and those will be used as to validate the will. But however, that does mean that the will no longer be considered self-proved. That's very important. It's no longer self-proved if we're having to take signatures on a self-proving affidavit to validate the will.
Megan?
Yeah.
Richard Anton asks, if another person signs for the testator, what name goes in the signature space?
Yeah, so the signature space should say the testator's name, and then it will usually say signed on, or signed at, it'll say signed by the person at the direction of the testator usually. There's also a section, I don't know off the top of my head, but I think it's in the Civil Practice and Remedies Code that even provides language for if you're signing a document on behalf of someone. We had a case come up recently where they didn't use that language, and judge still found that, you know, as long as they're indicating that it was in the direction of the testator, it's okay, but usually he'll want some additional proof of testimony. He'll usually want either whoever signed that will or a subscribing witness to verify, you know, it was in the testator's presence and at their direction. But there's also the language in the Civil Practice and Remedies Code that will just make it a more automatic process, because it very clearly, it's like a little affidavit that clearly says it was done in their presence and at their direction. Okay. So is the will self-proved? So there is a lot of material on this slide. We're not going to go through all of it, but this is just to show you these are the substantial requirements that must be included. For the two-step method and the one-step method. Two-step method is when, you know, you sign the will, the witnesses sign the will, and then there's the affidavit attached at the end that everyone signs again, and that is notarized. One-step method is where there is the clause, then there's the signature of the witness, then there's the attestation clause that also has the prove up language, the two witness signatures, and is notarized. So everyone's signing the will once. We see mostly the two-step method, but we do also see a lot of one-step method. The one-step method is only available for wills executed on or after September 1st of 2011. Okay, so if you have a will before that and it's seeming to do the one-step method, it is not a one-step method self-proved will. They have to be using the two-step method before September 1st, 2011. A common issue that we see with self-proving affidavits is that they're not in substantial compliance with the form affidavits that are in the statute. And pursuant to Texas State Code 251.104D, they need to be in substantial compliance. So if wording is slightly different, but the meaning and the core has not changed, then that can be considered in substantial compliance. So for example, one we frequently see, instead of it saying that the witnesses stated that the testator was 18 years or older and of sound mind, they may say a legal adult or was legally an adult. That we can consider to be in substantial compliance.
Megan?
Yeah.
Charles at Smystrela asks, what if the testator states he requested the witnesses to sign, but the witnesses do not state they signed at the testator's request?
In that situation, then the will not be considered self-proof, because you're not going to be in substantial compliance with the form affidavits that are in the statute. So in that case, you'll want to do the additional prove up. Okay, so another question. How about if witnesses don't say they were 14 plus, it says they were of legal age to witness a will? That would be fine, because that's still, we still have that core essence. Nothing's really changing there, so that should be okay. Some things that I highlighted that we're running into a lot. The test, often we forget to say the witnesses stated that the testator declared it to be his will. There's no, he never states that's his will. So we need to make sure that's in there. We also have been missing a lot of the at his request language that is tied to the witnesses signed as witnesses in the presence of testator, you need to say at his request or her request. Another thing we commonly run into with the one-step method is that we forget in the testator, like the testator attestation clause and the witnesses attestation clause, we forget to say that they were all present at the same time. This is really important for the one-step method to say that everyone was there at the same time, and they're all executing it and witnessing it together. Must the witnesses be in the presence of each other when signing? Under the two-step method, they do not. Under the one-step method, because we're saying everyone was present at the same time, you would need them together in that situation. Correct me if I'm wrong, Mike.
I do think they will, if only because I believe the notary juror needs to say that they were sworn
That's
into
true.
that testimony.
That's true. Yes. So for self-proving, that's actually really good. So for self-proving, yeah, you will need everyone at the same time. I guess I was thinking of cases we had recently. They weren't self-proved though. They were actually form wills, where what happened was they didn't have a self-proving affidavit attached, and there were a bunch of different dates on the will, and the attorney is planning on proving it up by having each witness attend, saying, yeah, I was in the presence of the testator on this date. And then the other witness coming up saying, yeah, I was present in front of the testator on this date, even though they weren't in the same presence. So, yeah, great question. So you will need them together in order for it to be self-proof, because otherwise you won't be able to complete the notary jurat. Okay. So here's a couple unique situations. We don't see these a ton, but I just wanted to kind of quickly cover them. Foreign wills, there's kind of two ways they can be considered self-proved. They can be considered self-proved under Texas Estates Code section 256.152C. And they can also be considered self-proved if the will is self-proved according to the laws of the state or the foreign country that the testator was domiciled in at the time the will was executed. So if you have a foreign will, you're going to want to look at these requirements to see if the will meets those for it to be self-proved. With foreign wills in your application, make sure you state the jurisdiction where the testator was domiciled at the time the will was executed. Ask the court to take judicial notice of the laws regarding the self-proof of that jurisdiction. Allege that the will is self-proved according to those laws, and then also as an exhibit attach a printout of like Westlaw or Lexis or another legal database that has the self-proving laws for that state. We do have a running list of every single state and their self-proving requirements, but we still always ask the attorneys, to do the due diligence, make sure you're checking the statutes yourself, and then also attaching exhibits, because these don't change often or update often, but every once in a while something might be discovered that we weren't aware of just because, we don't practice in those states. So it's always nice when you also attach those exhibits, because it also helps ensure everything's staying up to date.
That's important to note, because I believe we have had some states update their laws from when that running list was created. I think it was Vermont didn't allow for self-proving, but then by the time our case came up where it was an issue, they had allowed for it, and the will we had matched their requirements, so it was a self-proved will. So if you can do that due diligence and provide us with evidence, we're fine.
Yep, exactly. And then the other kind of unique situation we'll see is military wills. I think I've seen maybe 5 of these in the past couple of years. They just don't come up often, and unfortunately sometimes they're just not done right, so we can't consider them military wills. So with military wills, they're automatically self-proof if they meet the requirements under 10 USC 1044D. The interesting thing and the caveat that catches most people is that statute requires that there be a preamble at the top of the will stating that's a military will, and there's specific language. I believe subsection A of that code gives you that language. And often the military wills are missing that preamble. And if that preamble is there, we cannot consider it to be self-proof. So please just always just double check that code section and see if you're meeting those requirements. If you have any questions, feel free to shoot us an email. I had an email come up, I think just a couple of days ago, where someone was asking if it was a valid military will. And it had the preamble and everything that was required. So it'll be a simple prove up for them. Okay, so besides the self-proving affidavit language issues that sometimes come up that we just talked about previously, what are some common self-proving mistakes that the court sees? So the first one is the signatures are inconsistent. So that's where the signatures look one way when they're signing the will, and it looks a different way on the self-proving affidavit. Often this happens, and we can tell that it was the notary that either wrote their name on the will or wrote their name on the self-proving affidavit, and then the witnesses or the testator signed the other page. It's okay if they look slightly different, right? Our signatures, it's impossible for them to look exactly the same from page to page unless we had a stamp, right? But they should still look very similar. If I signed my name versus Mike signed my name, it would look very different. Even if he tried to copy me, it would still look different. So just try and make sure the signatures look consistent. Another big red flag when we see inconsistent signatures is sometimes we discover that there is a different witness on the will than on the self-proving affidavit. So that always make sure that the witnesses are consistent on the will and the self-proving affidavit. Another common error we see is if someone writes their name in print on the will, but then cursive on the self-proving affidavit or vice versa. Judge Herman will automatically consider it not to be self-proved because of what the signatures aren't consistent enough. And so in that case, you will need to do the additional prove up requirements. Also watch out for date changes. I haven't seen this recently, but Mike and I do see this a lot when there's wills that were executed right at the beginning of a new year, because often they were drafted in the previous year, then the new year rolls around when they're executing them. And so the attorneys, notary, witnesses, whoever will just cross out the date and update the date using their handwriting, which is fine, but you need to make sure that those changes are initialed. If it's not initialed, it creates a question of who actually made those changes and if it was done after the fact and when that will was actually self-proved and executed. So just make sure you watch out for that. But we don't see that happening too much right now, luckily. Also watch the notary jurat. The notary jurat needs to say subscribed and sworn. It should not say acknowledged. This can be found in the Texas Estates Code. So just make sure you're just copying that jurat. Might as well just copy it rather than wondering if your jurat's okay or not. Also make sure that that notary jurat does not have dates or names that are blank. If they are blank, then it creates an issue of were they all present and did they all subscribe and swear in front of the notary. So if there are ever blanks in that notary jurat, we can't unfortunately consider the will to be self-proved. Also, if there's no notary seal, we can't consider the will to be self-proved. We don't see this as much of an issue with original wills. It does become a problem with copy cases, because if a copy's been made, sometimes, especially if it's those indent seals, it just will not transfer over when you make a copy. So if you're probing a copy of a will, please double check to see if there's that notary seal. That's kind of the biggest problem I've been seeing on copy cases lately. Okay, are holographic wills considered self-proved? No, they are not. You will need two disinterested witnesses to testify to the decedent's handwriting. Fortunately, because holographic wills, you prove them up using handwriting witnesses, you will not need to file a motion for alternate method of proof. If you file one, it's okay, but you don't have to file one. So it's kind of nice, because if you forget to file one, you're already covered because you don't have to. Okay, so what if the will is not self-proved? There's two ways to prove it up. The first way is using a subscribing witness, and the second way is to use two disinterested handwriting witnesses. For subscribing witnesses, we actually, for both of these, it has been Interesting, lately, a lot of the prove up documents have been missing a chunk of the required information. So that's why I took the time to put, the core concepts on this slide. And I kind of bolded where the sections where I've noticed the information is missing. So you need to make sure that you state that the subscribing witnesses were credible over the age of 18. And you need to make sure you say that the decedent was of sound mind and over 18 years on the date the will was executed, okay? It's very common for people, no one really misses them saying, hey, I was a subscribing witness and I was there and I saw it happen. That's usually not the issue. The issue is more like, well, was everyone of sound mind and over the age of 18 or 14 and of sound mind? Were were both subscribing witnesses present? Just that, like, pretty much you want the language that you would see in the self-proving affidavit. You want that in your prove-up testimony. For the two disinterested handwriting witnesses, if it's not a holographic will, you need to file a motion for alternate method of proof. You also need to file the accompanying order. Those templates are on our website, okay? And at the end of this, I'll show you kind of on our website where all these resources are. So you don't have to reinvent the will, just take those templates, input your client's name, the estate name, and then just get them filed. The content with these, often it's not just enough to say you're acquainted with the signature and that it is the decedent's signature. You need to go through those steps. On the date the will was signed, was the decedent over the age of 18? Was the decedent of sound mind? Does the witness, you need to state that the witness does not have a financial interest in this estate as well, because we need verification that they truly are a disinterested witness. Okay, any questions on that? Okay, great. So now we're going to transition looking into more. So once we've looked at, kind of the big pieces of the will and the will as a whole, let's start digging into the actual contents of the will. Okay, the first thing, I put this big because this has become a very big problem, is what is the decedent's name? The decedent's name must be written on all the documents. So on your application, on your posting, on all your proposed documents, everything exactly as it appears on the will. There's no exceptions to this. So if the will lists 6 AKAs, then you need to include all 6 AKAs in all your proposed documents and in your application and in everything, okay? If there's a typo in the will name, it does not matter. You still need to use that name, but you can follow it up with AKAs. If the decedent went by other names or is going by a different name right now, does not matter. You still use that will name, and then you can just add AKAs and tack those other names on. So let's go through an example. Okay, here's a clip of a will. Frederick Joseph Flintstone, that's the name. So that is the name that has to be used everywhere. So here it is, Frederick Joseph Flintstone. That's what you need to see here. But then you go, but Megan, obviously he doesn't go by Frederick Joseph Flintstone, he goes by Fred Flintstone. Well, that's okay, you just add an AKA. So I have some examples here. I still use Frederick Joseph Flintstone first. Then I do an AKA with, it can be whatever. This is just an example. So say he doesn't really go by his middle name, you can just cut out that Frederick J. Flintstone and you can just go by whatever they use. And then what if they used to go by a different name? Then you can do a formerly known as. What if they now go by a different name? And this you see a lot, with someone gets married or divorced, things like that. Then you can do a now known as. Okay, so please, I cannot emphasize this enough. Please help us and just use the name as written on the will. It becomes a huge issue because you have posting issues. And also, Mike and I have given up on changing all the documents all the time. And so we're just going to send them back to you and tell you to correct them to do the AKAs right, because it's just become such a time suck for us.
We have an anonymous question. What if in most of the provisions in the will, the name of the executor is spelled correctly, but when actually named to be executor, the name is misspelled? Do I still need to use an AKA in that instance?
Yes, you'll still need to use an AKA. So you'll want to use the name as it is written in the provision appointing them and naming them as executor. This actually did come up in a case I had 2 weeks ago, I think. So you go based off that provision that's appointing them. And then from there, you just add AKAs on. You know, when you're adding those AKAs on, it shouldn't create any issues for banks or whoever is needing to see these documents, because it's also helping you link the person, you know, the will to the person, even if there's a typo. So please do this. Okay. So next thing I like to look at, does the will dispose of everything? So is there a residuary clause or just catch-all language? Some common examples we see are all the rest, residue, and remainder. We also see I give everything to whoever, I give all of my possessions, and I give all of my property. These are the most common ones we see. If it says I give my personal possessions, that does not dispose of everything. You'll see the intestacies, they're more common in holographic wills. However, you will see them in lawyer drafted wills. The most common situations where it arises is when there's like, the best way to put it is spousal survival language. So if they're saying something like, if my wife survives me, if my wife doesn't survive me, if my wife survives me by 90 days, if we die simultaneous, but they don't capture the other flip side of that. So if they say, if my wife survives me, I give her everything. But what if the wife doesn't survive her and they don't address that? That can be a problem, and that can create a partial intestacy or potentially total intestacy, depending on that will is drafted. Or the most common one we see is if they say, if we die in a simultaneous death, then I give everything to my children. Well, but what if they don't die in a simultaneous death? What if the wife is still alive? What if the wife predeceased? Then what happens to all that property? So just make sure you kind of walk through, especially when you see that spouse survival language. Just make sure, you know, the situation that's currently present in that estate is accounted for. If not, then you'll have potentially partial intestacy or total intestacy issues. What if the residuary leads to a revocable trust that was never funded and there is no copy? That is a great question, Stephen.
If there's no trust that was never funded, it's been a while since my estates class with Johansson, but I don't think that's a valid trust.
Yeah, I don't
think
think
the
that'd be a
trust-
valid trust. So then I think you're looking at a partial intestacy in that situation, because then there's a question of should all that property be going? So if you have this situation, we don't have a situation come up often, because for us, there's no way of us knowing if that trust is funded, right, or not. So unless the attorney's notifying us of that. So if the situation comes up, let us know. We'll go talk to Judge Herman about it. I think that's the best answer for that, because I think you'd potentially have an intestacy there, but I'd want to double check that with Judge.
We have another question. Candace is asking, if a name is in all caps, can court documents use caps lowercase? My application used caps lowercase.
Yep. Yeah, you don't have. It's not case sensitive or text sensitive. Case sensitive. So you know, it's just the spelling has to be consistent. One more thing I'm going to say about does the will dispose of everything? Watch for percentages in the will. I would recommend please just use fractions. We have had some wills come up where they're giving 33% of the residuary away. So they're giving, 33% to child A, 33% child B, and 33% to child C. If you add that up, there's still a percentage not accounted for. That percentage is a partial intestacy. So make sure if you're doing fractions like that, just go ahead and just throw in a 1/3. If throw in a 1/3, not as much an issue. Yeah.
Lisa also is asking, I give the bulk of my estate, she has a sample request. I give the bulk of my estate to X and Y, with the exceptions set forth below, in parentheses, gifts of personal property to others. Does bulk of my estate equal the rest of the residuary estate?
That's a good one. think bulk of my estate might not be considered residuary, because what is considered bulk of the estate? Is it just the remaining amount? Is it, 75% of it? So I think in that situation, we definitely need to just run that by Judge Herman to consider if he would consider that sufficient language.
Yeah, that's definitely kind of tricky. We'll have to do a little looking into that.
Yeah.
And okay, I have
I'm
two.
gonna chime in here. I don't read bulk of the estate meaning the remainder.
What do you read it as, Judge?
The bulk of my estate. I
75%?
think colloquially speaking, bulk is it's some but not all.
So yeah, it sounds like that is going to be problematic. If you see bulk of the estate, it sounds like it would be safer to, assuming it's coming up in an issue like a muniment of title or a will that doesn't create an independent administration, name an executor, waive bond, etc. You may want to consider declaratory judgment on the heirs. And Stephen Summer has a follow-up question. Do you probate the will if it names the descendants but has the intestacy issue? This avoids ad litem costs. What is the solution? Declaratory judgment.
Great question. Here we go. We can answer that. So what if there is a partial intestacy? If the will names an independent executor and waives bond, then it's up to the attorney and the client to choose how they want to go through that. I'm not going to tell you what to do. That would be providing legal advice, so my hands are off there, but you may want to consider, do you need to do an heirship determination? Do you need to do a declaratory judgment, or do you need to do a family settlement agreement? Or is there any additional way you should consider resolving that partial intestacy? You can keep the case on because the will does provide for an independent executor and waives bond. However, issues can come up down the road with that. What if property is not being distributed correctly? Who's on the hook? Right? You don't want to create liability issues there for both your client and for you. And also, you could have to pay additional filing costs to bring those causes after the will is probated. Or you can you can ask us to reschedule the case, and then you can get that declaratory judgment, that family settlement, or that heirship ready to go, and then we'll just reset the case when all of that's ready. It's up to you and your client, so that's something you guys will want to talk about, or your firm will want to reach like, hey, anytime this happens, we're going to do this. So just kind of think that through. What if we're going to talk about this situation? I'm going to talk broadly right now, and then we'll talk about what I mean when I say waivers and consents later. So what if waivers and consents are needed for this case, or you're seeking a dependent administration? In that situation, then an heirship determination must be completed. Okay, so we'll have to take the case. You're going to have to go through the heirship process. And then once you're ready to proceed with that heirship process and the will probate, then you'll email the heirships at traviscountykx.gov an heirship setting request form. Okay, so, but that does not, you still probate the will. Okay, you do both. You're going to probate the will and you're going to do an heirship determination. Okay, now what if you're doing a muniment of title? In a muniment of title situation, same thing. You need to do an heirship determination as well. Okay, now I'm saying, well, Megan, what if there's a total intestacy? So what if the will didn't dispose of everything because, there was, it kind of just gave it all in the residuary, but the residuary wasn't actually residuary. Well, then you're going to need to do an heirship determination. There's no exceptions to this. You have to do an heirship determination. You're still going to probate the will, even though there's a total intestacy. Judge Herman always still wants that entire will probated. Okay, so you're going to probate the will and do that heirship determination. Same situation, you're going to get all that ready, and then you're just going to email airships at traviscountykx.gov to get that case set once you submit that heirship setting request form. Okay, any other questions with intestacies? I know this is like kind of a funky thing. They don't come up often, but when they do come up, it gets confusing. So any more questions with that?
I just want to chime in, and this is something we've had come up this week. Judge Herman interprets wills to have a difference if it says, my children are Tom and Mike. And then later it says, I give everything to my descendants, and then never defines the descendants as Tom and Mike or the descendants to include my children. It may seem a bit confusing when we ask you to do that declaratory judgment if it were necessary, but there is a difference there. And if that comes up, we are going to ask you to define my descendants to include the my children.
Yes, exactly. And I'll talk about this further too as well a little bit later, but this becomes the big issue if we have a case where there's ever waivers and consents needed. So we definitely want to make sure we watch for that kind of stuff. Okay, so what if the first name of the executor is serving? Well, that's great. It becomes a pretty straightforward case. So first, once again, in bold, applicant's name must be written on all documents exactly as it appears in the will. Okay, please do this. So an example. Here we go. Here's two sections of a will. So if we go down to this section 6, it says, I appoint my wife as independent executor of my estate. Okay, so it just says wife. So we need to go and make sure that the will defines wife. So if we look near the top of the will, it said, I'm married to Wilma Flintstone. All references to my will are to my wife. So that's great. So we define it. So the issue is what if it said wife and it doesn't define it, then you're going to need a declaratory judgment. Fortunately, this doesn't happen often, but like Mike was saying, we are starting to see stuff like this a lot more common, especially when it comes to children and descendants, less so than spouses. So remember, name as it appears on the will. So you don't have to put wife. You don't have to do that. What you're going to do is put Wilma Flintstone. So the name needs to be Wilma Flintstone, and then you can follow that by AKAs, FKAs, NKAs, adding any of those additional names in. I don't know if Greg Johnson is on here, but Greg is the master of AKAs. Let me just say, I remember I think it was my first week at the court, and one of his wills came up, and I think there was like 10 AKAs on it. He's a master of them, and he gets them right every time. So just like, if you have questions and we can't answer them, always try Greg, because he is great at his AKAs. Okay. The next thing, does the will provide for an independent administration and waive bond? Okay, so let's take a look back at this previous example. Okay, so independent administration is if it should say anything like independent executor. It should say without court approval, free of court supervision. So we're looking for those broad, all-encompassing powers. If there is a laundry list of powers in the will, but it does not say that, everything can be without court supervision or independent administration, then that's insufficient. A laundry list is not the all-encompassing independent powers, okay? So we do see that coming up, not as much with Texas wills, but we see that a lot with foreign wills when people are trying to say a foreign will provides independent administration. The other thing I'll look for is, does the will waive bond? In this example, it's in this section 6 of B. It says, I direct that no bond or other security shall be had on any executor. So we want to look for those two key points, okay? So then the next thing, what if the alternate executor is serving? Some things you want to watch for. Does the alternate still have all of the powers? So do they still have, an independent administration, and is bond still waived? This becomes an issue, and I'll show you, we'll talk about it in a second. So why, and then you want to say, why isn't the first name serving? You need to put this in your application and your proof of death and in the order, okay? So if the person is deceased, then in this order, this is what the court prefers to prove up that the person is deceased. We want a death certificate. We want a statement in the proof or in the application that provides a cause number for that person's probate, or an obituary. If the person's incapacitated, then we need a letter from a physician. If they decline to serve, then we need a notarized declination or an unsworn declaration. If it's a felony conviction, we can either have a sentencing document, or you can also do a declination to serve. If the first name is a minor, we don't see this often, but it can happen in really sad circumstances where someone died young. then we need to see that minor's birth certificate. Okay, so when the alternate executor is serving, you will need to provide these additional proofs, and then you'll need to make sure, as I've said, that all of this, an explanation for why they're not serving, is in your application, your proof, and your order. Okay. So, does divorce automatically disqualify a named executor? Yes, it does. It does automatically disqualify them. So that should not be an issue. Okay, so here's an example.
I just want to jump in real quick. Just to explain a little bit, the divorce needs to be finalized and signed off by the judge and family court. If your decedent died before that was done, he died married, and that does not automatically disqualify the executor, which we have unfortunately seen a couple times.
Yes, thanks for elaborating on that, Mike. Okay, so here is the situation. Let's say that Wilma is not serving because she has, she's predeceased the decedent. So the next situation, Paula Lee Flintstone, AKA Pebbles Flintstone, is going to be serving. Notice how there is an AKA after her will or her name. Therefore, you need to have both names as her name in all your documents. So it'll be written as Paula Lee Flintstone, AKA Pebbles Flintstone. And then if there's additional AKAs that they go by, you can throw those AKAs in as well, like we've talked about. The thing we want to watch is, does the will allow her to serve as independent executor, or does it provide for independent administration, and does it waive bond? So this one, very straightforward, luckily. It says right here, as substitute or successor independent executor, and then that bond language still ties to her right here. I direct no bond or other security shall be required of any executor. Often, that language, the bond language or the independent language, sometimes it's just tied to that first name. If it's just tied to the first name, then you're gonna have to get waivers and consents from everyone if you want that alternate to also serve as an independent, and if you want their bond to be waived. So please just make sure that's tied right. You know, sometimes, unfortunately, there's some poor grammar stuff done, commas in bad places and things like that, and we have to go based on that language there. We can't just assume if it doesn't clearly say it. Also make sure, because I'm saying right now that Wilma's deceased, then you will need to put in the application and all those documents, you'll need to say Wilma Flintstone was named to serve as independent executor, but she predeceased decedent. The will names Paula Lee Flintstone, AKA Pebbles Flintstone, as alternate independent executor served without bond. Note that if someone has not already been appointed to serve, then they're only an alternate independent executor. They are not a successor independent executor. We've seen that language get kind of confused. A successor is only appointed if someone has, the will has already been probated and someone has already been appointed as independent executor. Otherwise, the person is just an alternate independent executor for purposes of the proposed docs. Their oath will just say independent executor, but in the proposed docs, make sure you just say alternate, not successor. Okay, so we're gonna go through a couple examples of, well, what if, you know, the will names an executor but doesn't waive bond, doesn't waive independent administration, etc. So we're gonna go through a few examples. They're all pretty similar, so I'm gonna go kind of quickly through these because once I cover one, it'll be similar for the rest, and then I'll let us talk about some more stuff. So what if the will names an independent executor and waives bond but doesn't provide for an independent administration? In this situation, you will need sworn consents from every distributee. That includes a request for an independent administration, a designation of the named executor to serve as independent executor, and a waiver of citation. So they need to waive service and they need to consent. If you look at Texas State's Code 401.0 for B, I believe it provides an example of what that like waiver and consent language can look like. So not only do you need those waivers and consents, you need to make sure you address it in all your documents, okay? So all three documents must explain why the will does not provide for independence, or that the will doesn't provide for it, but that everyone is agreeing to it and consenting to it. In your title of your order, here's an example you can use. It doesn't have to be this wordy, but we just want to make sure everything's kind of addressed.
Megan,
Yeah.
Rose Cohen is asking, will they still be appointed independent executor or independent administrator with will annexed?
Great question. Okay, so they will be appointed as independent executor. If the person is named in the will as an executor, they will be named as an independent executor. I'll go in a little bit later, I'll talk about when they'd be named as an independent administrator with will annexed. And that situation is only when the person you're seeking to be appointed is not named in the will. So that's a really great question. So some things you need to be aware of with these sworn waivers and consents. If there's a minor distributee, the court will not approve an independent administration because they cannot be consenting. If any of the distributees are dead or incapacitated, you're gonna have to address that issue first. So if they're dead, you're gonna need to potentially probate. Well, you'll need to have their estate probated potentially. If they're incapacitated, you'll need to look at if there's like a power of attorney or kind of what that situation is. If there's a trust, you'll need to look at see if the devisees of the trustee should waive and consent, and that's under section 401.004D. These consents must either be notarized or an unsworn declaration. Okay, so this is also what Mike was talking about before, right? Where it says make sure the will clearly defines, you know, descendants, children, anything like that, because this is when it comes into play. If we don't know who should be waiving and consenting in the will, then we don't know if all the appropriate people, right? If we've covered all the distributees and they've waived the consent. So that's when you can potentially need a declaratory judgment or an heirship determination. So, okay, now what if the will names an independent executor but doesn't waive bond? So same thing, you're just gonna get a sworn request from every distributee to waive the bond to allow the independent executor to serve without bond, and they're gonna have them waive service. Once again, all the documents, so the application, the proof, the order, everything needs to address it. So you're gonna have all three documents just explain that the will does not waive bond, but the distributees have requested the independent executor serve as independent executor without bond. Once again, those same situation with those waivers and consents. Is there a minor? Is the distributee dead? Are they incapacitated? All those questions you're gonna need to make sure you ask and address accordingly. Okay, so same situation. What if the will names an executor but doesn't provide for independent administration or waive bond? Same thing, you're just gonna get some waivers. You're gonna make sure that those waivers waive citation, they have a request for an independent administration and a request for that waiver of bond. Once again, all three documents need to address it. And then, you know, so make sure it's clear that, you know, the will doesn't provide for independent administration or waive bond. However, all distributees have agreed on the advisability of it and have consented to whoever serving as independent executor without bond. And then once again, those issues, minor children, just if they're dead, if they're incapacitated, if there's a trust, all those issues come up again. So make sure you're just looking through that and addressing accordingly. Okay, what if so this is going to tie back to Rose Cohen's question. What if the will does not name an executor, or all of them are deceased, declined, or disqualified? In this situation, you have an independent administration with will annexed. Okay, independent administration with will annexed. This is an issue we see a lot of in all the documents. Okay, they're not an independent administrator. They're not an independent executor. They are not receiving letters testamentary, and they're not receiving letters of independent administration. They are an independent administrator with will annexed, and they're receiving letters of independent administration with will annexed. It is wordy. It's annoying to type it everywhere, but that is what they are. So please use that language consistently through all of it, okay? So if you're going to have someone be independent administrator with will annexed, the first thing you need to do, if there's no one named in the will, it's pretty straightforward. You're just gonna say, you're gonna get all those distributees to file those waivers and consents, saying that they're waiving bond and allowing whoever it is to serve as independent administrator with will annexed. Then once again, you're gonna make sure that's addressed in all your proposed documents and your application. The thing to make sure you know, with this order, you really need to make sure that the order title says order probating will and authorizing letters of independent administration with will annex. You need to make sure you're using that language throughout, okay? Now, what if they're all deceased, declined, or disqualified? So you're gonna need to show that. So you need to show that the same way you would show as alternate independent executors. So if they're deceased, you need a death certificate. If they're incapacitated, a letter from a doctor. If they're disqualified, you need, the felony conviction or, the declination. If they're declined serve, you need a declination. So all that kind of stuff. Once you've kind of proven that everyone that was named is no longer available to serve and no longer has, priority, then the independent administrator with will annex can serve, okay? So you've got to show that first though. So you need to make sure you're showing that in all the proposed documents and you're sending us the required proof. So please make sure you're doing that, because often we get these things that just saying, oh, this person's going to serve because no one else is available. And we're like, whoa, why aren't they available? So please elaborate. Also, a common thing that I'm going to touch on briefly that we're seeing, if there are independent co-executors named in a will, but only one is serving, if the will says that that person can serve by themselves, then that's totally fine, and they can serve by themselves if the other person declines. But if the will does not allow an independent co-executor to serve as sole independent executor if the others declined, then what needs to happen is you're going to have to turn it into an independent administration with will annex. So that means you're going to need to get everyone to decline to serve, including the person that wants to serve, because they need to decline to serve as independent co-executor. Then you're going to need to get everyone to waive and consent to that person serving as independent administrator with will annex. I know it gets a little complicated. So if you have one of these situations happening where, a co-executor doesn't want to serve, but the will doesn't allow, the other person to serve as sole executor, then just, email the court and we'll walk you through it, because it can get a little complicated, because you just have to get everyone to decline, then all the beneficiaries to consent to an independent administration with will annex. Okay, so what if they're handwritten interlineations? Okay, so they're valid codicils when the handwritten interlineations are initialed and dated. Make sure that the posting, application, and proposed documents reflect the codicil. And then you're going to need to prove up that codicil. If there are handwritten interlineations that are undated and initialed, and a subscribing witness can testify that they were done before the will is executed, then they're part of the will. They're actually not codicils. So, maybe double check that. So they're not valid if they're just crossouts and changed, and they're not initialed and dated. In the situation where they're not valid codicils, we will put in the order that we're only probating the will as originally typewritten, okay? Because we don't want any confusion, especially if there's some big changes being made that weren't valid codicils. Okay, so what if there are codicils? So you're going to go through the same review process that we just went with the will, but there's some things you're going to want to watch out for. Is the will, or is the codicil to the will that the court has on file? This came up a few months ago where the codicil said it's a codicil to a will made May 1st, 2018, but the will that we had on file was made August 2020. So that creates an issue, because then, that codicil was probably revoked. You need to look at that will, but that codicil should have been revoked. So then therefore it's actually not a valid codicil that should be probated. So make sure that the codicil and the will are matching each other. And then you want to look, what is being changed in that codicil? Is an independent executor changing? Is the residuary clause changing, or beneficiaries changing? Take a look at that, because that could affect how you're drafting your application and your proposed documents.
Megan?
Yeah.
Richard Anton is asking, what if the will is not dated, but testator later interlineated and added the date in his handwriting?
The will isn't dated.
Right.
So the will isn't dated, but then he added a handwritten interlineation, like he changed an executor, for example.
It sounds like from his question, if they executed the will and then later that day he realizes, oh, we didn't date it, and then signs the date. If I'm reading this right. And Mr. Anton, if I'm not, please feel free to send it to the chat.
in that situation, I don't know how,
I think if nothing were signed at all.
I don't understand the question. So yeah, do you understand?
Okay, so he's saying that's correct. The will stated date signed, but we didn't change to the exact date. So I'm assuming there's a blank. There's a blank throughout the document. And then later he's handwriting in, this was signed on April 13th. I think we're going to need a subscribing witness to come in and testify that that's when the will was actually signed.
Yeah,
Unless he does that, he initials and the subscribing witnesses and the notary also initialed, because it seemed to be pretty much of a stretch to assume they'd get all those people to come back and initial an interlineation. That didn't happen.
yeah, that sounds about right. Because I think we won't want to consider that self-proof. We need like a subscribing witness. Okay. Some additional requirements for codicils, they must be posted for, okay? Sometimes, so the best way to make sure your codicil is posted for is that it's in the title of your application. Sometimes, you know, the clerks will accidentally forget to put that codicil language in. I always am really, you know, when I'm doing my reviews, I check, I'm like, is it in the application? Okay, they put in the application, so there was some mix up down in the clerk's office. So that happens, I immediately email the clerks and try and get it resolved for you and get that posted out quickly. If it is an attorney error, you're gonna have to repay the posting fee. Clerk error, you won't. If so, also make sure that you're discussing that codicil in the application and the proposed documents, okay? Yeah,
Chesser is asking, will revoked prior codicil, but will tries to incorporate the codicil by reference. Does that work? To be honest with you, I think incorporation by reference is probably tricky enough that it would kick this case off an uncontested docket and put it on the regular. I'm a bit hard pressed to remember the requirements for incorporation by reference, but it's not something that's going to be a real quick 5-minute hearing. We may need a little bit more testimony and evidence about that.
yeah, so we'll want it, in that case, you'll want to put on the regular docket, and then we'll need to just talk to, you want to give us a heads up so we have time to talk to Judge Herman about, figure out what he wants. Okay, so we're running short on time, so I'm gonna run quickly through some stuff, because I want to hit the big hitter stuff, okay? So if I skim over something, bear with me, because we're gonna send all these out. I put a lot in here so that way, because I knew we'd send them out so that way you can reference them. Okay, application. There's some here's the requirements for the application. We're not going to talk and walk through all of them. The big things to watch for: the decedent's driver's license and the applicant's driver's license. Under the Texas Estates Code, a Texas identification card is not a driver's license, okay? So we're seeing this a lot in applications right now. If you use a Texas identification card, we're going to ask you to amend your application to either say, provide the driver's license, or say the numbers are unknown, or the decedent did not have one, okay? Make sure that you're looking at the place of the decedent's death and the domicile. Make sure you're correctly stating that information, especially if there is a discrepancy with what's on the decedent's death certificate. You need to address that discrepancy in your application. You also need to address it in your proof of death. Also, the name and physical address for the service of the executor or administrator. I highlighted this because this is where you should also be putting, if the first name isn't serving or alternates aren't serving, or if you're doing the independent administration with will annex, this is where you need to walk through that. This is where you need to say first name isn't serving because of XYZ, or we're doing independent administration with will annex because of XYZ. Also, charity language. You need to include a statement as to whether or not the state of Texas, governmental agencies, or charities are named in the will, and that includes charitable beneficiaries, okay? So, what will disqualify my client? We're going to talk about this real quick. If they are incapacitated, a convicted felon under state and federal law, if they're non-resident who is not appointed a resident agent designation to accept service, if they're a corporation not authorized to act as a fiduciary in Texas, or any person the court finds unsuitable. The big thing for this is the non-residents. If you have a non-resident applicant for a muniment or an independent executor for letters, you need to file a resident agent designation. That designation needs to be executed by the independent executor or the applicant, and then and then, notarized, unsworn like that. The resident, you as the attorney who is a resident agent should not be signing it. It needs to be the person that the resident agent designation is for. Note, even though there's a note, even though with Muniments there's not an independent executor, that applicant, Judge Herman still requires them to have a resident agent designation. Okay, same thing, application for Muniments. The thing I want to highlight once again is that charities, if there's charities or government agencies, anything like that, then those need to be noticed either by service or waivers for Muniments. We don't see this often because usually once a charity or any of those are involved, they'll just switch over to letters, but just be aware that is a requirement. It's a fairly new policy we have. Make sure you're including that Medicaid language. For that Medicaid language, if the decedent did apply for Medicaid or anything like that, then you're gonna wanna make sure that you file that MERC. Okay, make sure that gets filed just to verify that there's no claims or anything like that. And then lastly, that statement about no unpaid debts unless they're secured by real property. With that, if there are debts outstanding, you're gonna need to make sure that those are paid and that we have proof of payment for those before we will do the muniment title.
Megan?
Yeah.
Referring back to resident agents, Richard Anton is asking, can the attorney for the executor act as resident agent?
Yes, they absolutely can, and that's usually what we see. The only thing is just that attorney cannot execute the resident agent designation. The applicant has to do it. Okay, death certificates, very straightforward. I'm gonna skim over this. The thing though is watch that county of residence. If it doesn't say Travis County, you need to address why it doesn't say that and why this is the correct county and why we have venue. Okay, so please watch that. Posted notice. I get a lot of questions. Should I be reposting? So let's talk about that. For posted notice, do I need to repost? You're going to need to repost if the decedent's name or the applicant's name does not match the will. You're going to need to identify if the applicant changes, you need to repost. If there's a codicil added, you need to repost. If the posting does not refer to the codicil, you need to repost. If the application changes from a dependent to an independent administration, you don't see that as much with wills. You're going to see that more with heirships and things like that. Then you're going to need to repost. If the over 4 years special notice is not included for muniments of titles over 4 years, you got to repost. Or if the copy of will notice isn't, you got to repost. Minor changes don't require reposting. If I'm telling you some changes need to be made to your application or whatever, and I don't tell you that you need to do a posting, you usually don't need to do a posting. If you need to do a posting, I will tell you up front that you need to do a posting. Because I often get people asking, well, if I make that change, do I have to do a posting? Not necessarily. It's only if these big things are changing. Okay, so proposed documents. This is the big thing that I wanted to talk about. With proposed documents, now that we're back in person, you need to be switching over your jurats, okay? The big thing to note, it needs to say subscribed and sworn, cannot say acknowledged. It also needs to update to change because right now we have a different county clerk through the end of this year. So please note that. Quick thing with oaths, make sure it says oath of independent executor. It actually gives the decedent's name and you're addressing the right documents. If there's a will and codicil, it needs to be in there. Okay, one quick thing about who's testifying for proof of death, it needs to be someone with personal knowledge. Often attorneys try and do that proof of death testimony. Think of it this way, if you are friends with that person outside of your work relationship, you can give that proof of death. If you only know that information from your work relationship, you should not be giving that proof of death. Okay, I want to skip these proposed document stuff. This is just straightforward, stuff because I want to talk about the copy and the muniment over 4 years, okay? But one thing first, muniments of title. One thing I want to say, with the affidavit of fulfillment, whether it's waived or not, you need to look in the will to see if the applicant is the sole beneficiary. If the applicant is the sole beneficiary, we can waive that affidavit of fulfillment. If the applicant is not the sole beneficiary, we can't waive the affidavit of fulfillment. If there's a trust document, we need to see the trust document to see who the beneficiaries are. You don't have to e-file that, you just email it to us and we'll take a look. Okay, I just want to quickly touch on these because we've already talked about them a lot, but let's just talk about the differences real quick. So for additional requirements for the copy of will, you have to have an attorney ad litem posted or appointed, sorry. Your application needs to say copy everywhere. You're going to have to say why you can't produce the original will, and then all the distributees and heirs information needs to be provided. Additionally, that posting has to include a special notice. Waivers and consents need to be provided, and there are special waiver consent. And then at the hearing, you'll need to have a disinterested family history witness testify. That family history witness needs to testify to the entire family history. So for example, if the person was not married, didn't have kids, and so the parents are inheriting, it's not enough to just say that the person was unmarried, didn't have kids. That's not enough. You need to have someone that can also testify that he was survived or she was survived by her parents, and these are the parents. So you need to be able to tie it all the way to the people that will inherit. Okay, so please make sure you do that, because we often are getting somewhere else that says, oh, they're not married, not have kids. That just won't cut it. That posting, the special notice for the posting and the waivers and consents, those have specific language. Both of those can be found in administrative order on our website. Okay. The muniment and title is the exact same. The only difference is you're going to have to prove why they're not in default. And then same thing, the special notice and then the waivers and consents, those can be found in administrative order on our website. Just copy them verbatim. Please just copy them verbatim. That special notice, you shouldn't need to do anything. The clerks will automatically do it. For those waivers and consents, make sure you just use that special notice we have verbatim. Okay, one last thing, successor cases. We are having these popping up more and more. So let's just quickly talk about them. You need to do the additional filings. You need to show why the independent executive as appointed is no longer serving. So that's very similar to those why the alternates aren't serving. Okay, so if it's death, incapacity, you just need to prove that up. The application, it's a shorter version of will probate because you don't have to probate the will. So please don't include language probating the will. You do not have to do that. Same, you need to make sure the posting says successor, and then your proposed documents similar to the application. You're not probating the will, so please do not include language probating your will. Okay, so you're just simply getting that next person appointed. Usually when these come up, I'm usually having to revamp the proposed documents a lot. So if I do that, it's totally okay. I understand it. They don't come up often. Just update your templates though for going forward. So I went over a lot, especially near the end there because we ran out of time, but I really want to focus on that front stuff at the beginning a lot more because that's our heavy hitter stuff. If you have any questions, we have great resources on our website. This is a screenshot from our website of our resources for will cases. So if you go on our website, click on the probate tab, we have all these resources. The big one that I'd highly recommend you look at is that check 10 key points in the will. That is very similar to all the stuff that I just walked through. So take a look at that if you have any questions. Please look at these resources. I always ask that you check the resources before you email us. We're obviously happy to answer questions, but we handle so many cases and we have so many attorneys coming through here and cases coming through here. We just ask, check the resources first, because often you'll find your answers there, but then if not, of course, please email us. So, I know we're like out of time, but if there's any other questions, please let me know. I can stick around to answer questions. If anyone else needs to fall off, you totally can.
Rose Cohen has a question. If the day is correct, but the typed month and year is crossed out and handwritten in and initialed on both the will and the self-proving affidavit, what needs to be done?
Nothing will need to be done in that case because that change is initialed. So we'll consider that okay.
And I was also chatting with Mr. Anton, and just so that everybody else is aware, the court returned to in-person hearings April 1st for all matters. We had a very limited Zoom docket for uncontested will prove-ups only, but that was until the end of May when our current Zoom authority expires. I believe that docket has now filled up. So if you have an uncontested setting and you have an out-of-state witness or applicant and they can't physically come in, you're going to need to get their testimony done by deposition on written questions.
Yes, and quick thing, I did put in here deposition on written question stuff. Somewhere in here. Okay, so when these get sent out, you can look at this. These are the requirements for deposition on written questions. We've been seeing issues with this. I should have highlighted this as well. You need to file a notice of that intent to take deposition. It needs to be posted for, and the the interrogatories need to be posted as well. And they have to sit for 10 days before they can be answered. If an attorney ad litem is involved in the case, because it's a copy case and muniment over 4 years or an heirship, that attorney ad litem needs to be involved in the drafting process because they have a right to cross-examine. Also, one thing to note, if you're going to do depo on written questions for a subscribing witness, there is a special motion for alternate method of proof that needs to be filed. That can be found on our website. So just be aware of that.
We also have an intern who's working for us, and she's working on creating some sample depositions for heirships and wills, because sometimes, not that often, it's pretty rare, but the deposition will miss an important question we need. And we unfortunately can't proceed until that deposition is corrected. So we're working on getting some sample depositions up, and we'll add them to the resources on the website when we do, in case you've perhaps never done a deposition for an heirship case, for example. So those will be forthcoming, hopefully, in the next few weeks. Stephen Summer has another question. What if attestation, sorry, the chat shifted. What if attestation clause is not dated, but self-proving affidavit is, as well as the jurat?
Then that will can be considered self-proved, because if you got the self-proving affidavit dated and the jurat, then we know that everyone was present at the same time.
And Tyler Davey is asking, if will names charity as beneficiary in event descendants don't survive, and will is probated before descendants meet the 120-day survivorship requirement under the terms of the will, does the AG's office need to be noticed? Can applicants swear that no charity is named in a will?
Hold on, let me look at that.
Yeah, check that out.
In that case, so in all our applications, we ask that you just identify who all the beneficiaries are, charitable beneficiaries are. So in that situation, the application should include all the information.
If
I
there's,
think you'd want to wait the 120 days.
Yeah, but yeah, you should wait, because if anything changes, that's kind of like a big thing for more than just the charities, potentially, depending on how that will is structured.
yeah. Okay.
Any other questions?
I think that's it.
All right. Well, thank you very much, Megan. For everyone, I posted the CLE course number, today's course number in the chat box. It may have gone too far up with all the questions that came after it, so I'll say it again: 174-154-927. I'll not say it again, but say it for the first time. And I also dropped in the chat box the QR code if you'd rather just scan that code, and it'll automatically take you to the website with all the information provided. You should be able to do that as well.
What about the PowerPoint? How are we going to get that out?
We can, if you want to see if you can drop it into the chat box. I don't know if that'll be too large, but Megan, you can try doing that. Oh, you're still, let me stop sharing your screen.
Oh, yeah, thanks.
And we can get that sent out. Otherwise, if you provide your email when you registered, I think we should be able to send that to you, kind of do a mass email.
Yeah, I think let me see if I can drop in. If not, we should be.
Well, I will go ahead and stop recording this. Thank you all again for attending today's CLE, and we hope to see you next month, May 25th. Mike Jones will be presenting on airships.